Welcome back to Estate Planning Nightmares and How to Avoid Them. I'm your host, Jon Braddock, author of Click Here When I Die and founder of the Legacy Vault by My Life and Wishes. Today's guest has a story that takes us straight into the digital age, a time when a single click can change a family's future forever. It's the kind of modern estate nightmare we're seeing more and more. One that shows how simple misunderstandings and missing lines of documentation can literally unravel decades of family harmony. And so to help us unpack this case and explore how families can protect their legacies in a world of instant payments, I'm joined by Andrew M. Ayers, an accomplished estate planning and business attorney, speaker, and author of How Contracts Become Lawsuits. Andrew is the founder of Andrew M. Ayers, PC, where he spent over 20 years helping families and entrepreneurs protect what matters most, their loved ones and the businesses that they have built. He's known for his approachable, plain English style, making legal planning feel less like a chore and more like a smart, empowering act of love. Andrew, welcome to Estate Planning Nightmares and How to Avoid Them.
Thanks, John. I'm really happy to be here. I'm looking forward to our conversation today.
I am as well. I know you do a lot of speaking and engagement, so I know this will be it'll be a fun time. Mm-hmm. All right, so we've known each other for a little while, and I was really interested because we follow each other on LinkedIn, and I noticed you had a story about a $50,000 Venmo payment. And it really hit a nerve. Can you share that story with our audience?
Sure. And so it was an interesting situation where we had a father and two children. And what happened was the father had given $15,000 to the son. So we have a son and a daughter. And then unfortunately, the father passed away soon after that. And in the probate court proceedings, it became an interesting discussion of what was that $50,000 payment. So the son said, well, this was for consulting work I'd been doing for dad's business. The daughter, however, knew the truth was that her brother had been buying a house and dad was kind of trying to help him and had given him $50,000 towards that purchase of the new house. The challenge is when we do something like a Venmo payment or most types of electronic payments these days, there's no context for what that payment is really for. There's no proof of what dad intended. There's no documentation on purposes. And, dad and the son didn't have a formal consulting agreement. There was no agreement for investing into the house. So we're stuck in the situation with really, he said, she said, between two children trying to figure out what this $50,000 means. And in the context of this estate, the real question is the $50,000 an advance to the son against his estate, or is it not an advance, in which case he gets 50,000, he gets 50,000 outside of the estate and then shares the rest with his sister. So if we're looking at it, let's say there was $500,000 to be split. It really is a question is, are they splitting it 250 each? Or does he get that first 50,000 and then the two of them split the 450 that would be remaining? So for the sister, this was a significant amount of money. She could use all the money that was being distributed from her father's estate. And then, what happened is the two siblings had to hire an attorney. At last I heard there was $35,000 worth of legal fees involved. Their relationship has gotten pretty rocky. They really aren't doing family holidays anymore. And what happened for dad's legacy after using this online payment without context is he's really destroyed that legacy. It's become a legacy to the lawyers who are making all the money while they tried to sort out this situation. And so from that, the story became, how can we protect our family gifts in the digital age? And I'm happy to go through that, or we can, stop here and dig into the story more, whatever you would like.
Oh, that's awesome. Awesome story, not awesome for the people in the situation. It's interesting. I happen to use Venmo. Some of my children are still on my cell phone package because it's cheaper to be on there, but they Venmo me money once a month for their bill. And there is no real context. I mean, there's a place for notes, right? But usually the kids just put like a emoji of a cell phone in there. It's for the cell phone payment. So I can see where that gets very confusing. And
Mhm.
as our audience knows, and as you mentioned, children rarely agree whether they're young or whether they're adults. And to figure that out, so they had to hire an attorney. They spend $35,000, which again, now the state has dropped from, call it a half a million, right?
Mhm.
Down to 465.
Mhm.
Um, did they each have to hire their own attorney because they were kind of fighting over it together, or did they get one attorney to kind of balance it up?
Well, so I think in the end there ended up being three attorneys involved because they each had their own attorney, and then they had an attorney to try to mediate the situation. And it's one of the biggest challenges we have in law when you have a dispute over, I don't want to call them small amounts because it's your legacy going to your children. $50,000 is not a small amount in that regards, but when the legal fees start adding up, how much money do you want to pay to attorneys to fight over a $50,000 $50,000 from the state? If you each end up spending $45,000, then you've eaten all that up. And that's, whether it's in the commercial context, whether the estate context or anything else, that's really the biggest challenge we have in law is the economics of some of these smaller disputes that are still really important to families, and we still need to figure them out.
Oh, interesting. It leads me to another question because I know with Venmo, um, much like PayPal, I can send money, I can receive money, I can request money. And I can see a scenario where, and I don't want to say this would happen out there, but in a case of maybe some elder abuse or something along those lines, where a family member sends a request for payment to an elderly family member and list it as whatever they listed at. And mom or dad say, "Oh, okay, yeah, he's going to take care of my tax obligation or something with this," and boom, all of a sudden the money goes out the door. Is Are situations like that, where digital payments or quick transfers uh, becoming more and more evidenced in probate disputes?
They are, and and actually, I think another thing we haven't talked about yet is Apple Pay. I mean, we all love Apple Pay. If you have an Apple device, they've made it even easier to get this money being transferred around, and it goes beyond the probate. I had a case recently where we learned that one of the business owners was actually using Apple Pay to transfer money out for supposed business expenses, but they were actually personal expenses. But the way it showed up on the business statements, it didn't show up as anything funky. So when the accountant did the year-end books, that's when it got caught, and then that created a big issue in that business as well. And then we go really far, and let's go into Bitcoin and cryptocurrency, where there's little to no documentation, and you've got significant sums of money that can be moving around through the transfer of those cryptocurrencies. And that's, I think, one of the biggest challenges we're finding is we don't have as much context when we're dealing with these digital transfers as you had in the old days when you had a check. I mean, if you remember, you used to have a check and you'd have written on the memo what this is for. Going back to our Venmo story, this dad would have written, for the house, for the consulting, advance on inheritance, whatever it was. And a lot of times, you're clicking on your phone and you're sending the money. Nobody even wants to fill in the memo. It's just an extra step you don't want to take. So just send the money and be done with it.
Oh, yeah, and it's interesting too because, and I know some banking arrangements have kind of some rules around what you can do. So Zelle, for an example, I believe with Zelle, um, you can only, in some cases, send $1,000 or $3,000 in a 24-hour period, which can help, I think, mitigate some of the, boom, here's a $10,000 transfer, or worse yet, a $50,000 transfer. But like with Apple Pay and those things, that's not the case, right?
Yeah, I'm not sure what the Apple Pay limit is, but I think kind of the issue is the same across whether it's Zelle or anything else. And maybe it's not 50,000. I mean, a lot of families they don't have that money, but maybe it's just $10,000 to help with the down payment of the house, or $5,000 to help with a couple months of a mortgage payment or a down payment on something else. So there's a lot of money that's being transferred between folks digitally these days, and without that real trail or the demonstration of what the intent is, as lawyers, we're stuck coming in after the fact trying to ascertain what was intended. And in the context of a probate, usually the person who can answer the question is no longer with us. So we're stuck with two different sides, and everyone has their own intentions of how they want the money to be spent or how to be credited. So it can become a real challenge for us.
Yeah, absolutely. And in this Venmo case, clearly the only two people knew about. One of them's not talking,
Yep.
and the other is going to, explain it the way they want to explain it,
Hmm.
right? So
Yep.
I can see where the sibling discourse would come quickly into play.
Hmm.
Wow. So, so what should people think about in that context then? You know, what kind of context should people be creating every time that they make any kind of a gift or a transfer?
Sure. So if we're doing family gifts and especially when we're using electronic transfers, I usually have four suggestions for folks. Suggestion number one will be to document major gifts. So you want to have maybe an email between yourself and the person who's getting the money, explaining what that gift is for. State clearly that what you're giving them is a gift, and you want to save that documentation. So the nice thing about the email is you have a copy and they have a copy. And if I were the father in this situation that we're talking about, I would have CC'd the daughter as well because they have a smaller family, just the three of them. So everybody knew what this was. The second strategy we can use is to update our will after giving someone a large gift. So the father could have done a simple codicil that acknowledged that he had given $50,000 to the son and that he's adjusting the distributions in his will accordingly. Or he could say, I've given 50 to my son, so I'm now giving an extra $50,000 with a specific distribution to my daughter so that everything is going to be evened out. And if you're working with an attorney, which I'm hoping you are, you would also then tell the attorney. So we don't want the attorney to have to be a witness in court, but sometimes we do have to be the witness and we do have to say, Judge, Mr. Stevens came to me and he said this $50,000 was a gift to his son. He meant to update his will, but just hadn't done it yet before he passed away. Strategy number three, if we're using something like Venmo, we want to make sure we're using very clear payment descriptions. We love emojis, and I know when you like type the word house in, it immediately tries to get you to use the house emoji. Instead, explain in your Venmo description what it's actually for. You'd write something like gift for down payment on the house, no repayment expected, or advancement of inheritance, however you want to treat it. But as opposed to just using the little emojis, make sure you give a little context. Think of it like the old checks we all used to write. We want to make sure we're filling in that memo section. And the fourth strategy, you can actually do a gift letter where you just a simple one paragraph that says what your intent is with this particular gift. You can have both parties acknowledge it, so you can even have your son sign it. I don't know that you need to have your daughter sign it in this context, but just a nice documentation showing what the intent was with this. And then you could store that gift document, that gift letter with your other estate planning documents.
Brilliant. I think those are amazing. Yeah, you know, it's all about being very clear and communicative with all the parties concerned, right?
Mm-hmm.
I like the whole concept of, as you mentioned, even an email with the sister copied on it indicating what this was and what it is for, which would make your job at the end of the day much easier and save 35,000 from hiring a couple of additional attorneys, right?
Sure. And your purposes can be whatever you like them to be. So one of the common misconceptions we get is that if I have three children, they each get one third. You can have a very good reason why one child gets 50% and your other two get 25%. Let's say that first child's been living with you, helping you, supporting you, and you want to give them a little bit extra. So what we can do with that email or any of those strategies is really give context to why that money was given. And don't feel guilty. It's your money, it's your estate. And if you want to leave an uneven distribution, more power to you. It's your money. You can choose to disinherit a child entirely. I've had plenty of clients over the years who are just estranged from the child. Maybe something happened and they're just cutting them out entirely. And when we have those situations, whether it's an electronic transfer or not, we want to have it well documented so that we're leaving behind context for what that estate legacy looks like.
Absolutely. Absolutely. Yeah. And it's interesting, we all talk about what we want to be fair to, all of our children, right? But another estate planning attorney had said this to me one time, and I've heard it numerous times from others. It's that fair doesn't necessarily mean equal,
Right. Yep.
right?
That's a very common one we run into. Yeah, absolutely.
Yeah, and I know those are discussions you have with your clients when they come in when they're building an estate plan and
Yep.
working through distributions for the end of the day. Um, so two questions. What for a lot of people listening probably right now, I say, well, that would never happen in my
Mhm.
family. What would you say to that?
It never happens until it does. I mean, nobody ever thinks it will, and then it happens to somebody, and now you're stuck in the middle of it. A lot of times we have parents who think they're going to live forever. I just had a woman in this week who her domestic partner, they were never married. She did her will with me. Everything was in line for her finances, and her partner just, he never thought he'd get sick. He unfortunately got cancer, and it was very quickly downhill. And they're left sorting everything out. And that's even a more challenging probate because he didn't have a will. She wasn't his spouse, so she doesn't have a right to inherit, but they did have some assets that were joint that go to her. So you may not think this is important, or you may think you're going to live forever, or you may think you'll get to it someday, but it's a lot simpler than you think it is just to get it down, get it written on paper, and get it in place so you don't run into these issues. And, the reality is, if it's your estate, you're not the one who's got to sort it out. You're just leaving behind the mess for your family. And I don't think you want to leave that legacy towards your family. I mean, you don't want people besmirching your good name after you're gone.
No, absolutely, and you hear it all the time, as do I. I mean,
Mhm.
people are like, well, yeah, I know, I'll get around to it. I've got time. Well, you do. You have time until you don't, because none
Mhm.
of us know what tomorrow holds, right? So
Yep.
get it planned. I just recently, 2 days ago, got back from Florida. My wife and I were down visiting my parents and celebrating Dad's 94th birthday. Um,
Mhm.
um, Hopefully, he's got a whole bunch more left in him, but I know he's done his planning, so yeah, he didn't wait until the last minute.
Yep.
Um, so kind of we'll put a bow on the whole money transfer thing, but do you think the legal profession itself needs to evolve more? I know you have because of these experiences, but maybe even start asking their clients about Venmo, Zelle, PayPal habits during their estate plan reviews.
I mean, I think it could be a good part of the discussion. I think it shows the importance of being comfortable with your attorney. So one of the things that I will always talk about with a client in our first meeting is that they may not get along with me, and that's okay. So not every attorney is perfect for every client, and you need to be able to have that good, open relationship with your attorney. Feel comfortable sharing. I've shared in the past on LinkedIn where I had a mother come in. So it was the mother and her second husband, and then three children, and the spouses of the three children. So we had a packed conference room, and we were there to talk about mom's estate. And it just evolved into a big he said, she said fight amongst the kids of who's getting what, and I should get more. And, the stepdad essentially sat in the corner hiding behind his water bottle, and mom just looked embarrassed the whole way through. And she came back about a week later and she apologized for it. She said, I'm so sorry for the way my kids acted, and it's just a big spectacle. I said, don't worry about it, that's fine. You and I are here now. And then so she and I put together the estate plan that she wanted, not the estate plan that her three kids were fighting over the week before, because each of them thought they were entitled to more than one third. And frankly, what was really happening is they were mad that mom had remarried. Nobody liked stepdad, and they were concerned that stepdad was going to take away part of their inheritance.
Oh, yeah. Yeah, chalk that one up. Never bring
Mhm.
the family, the kids along
Mhm.
when I'm working on my estate plan. They'll get to see what's in it after I'm
Mhm.
gone.
You could bring them, but I think the importance was for the client to actually know that she could talk to me without them there and tell me what was really going on. Because once everyone else was gone from the room the following week, she really got to the bottom of they hate her new husband. She loves him. It's her second husband. Her first husband had passed away, but the three kids just hate their stepfather. And that's why it became such a circus. And she was comfortable saying that to me without anybody else around. But she was intimidated by having a room, frankly, with six other people between her three kids and their spouses. And then, her new husband just wasn't that forceful. He understood his role in this family, and he was new to the family, and he didn't want to rock the boat. So I think, finding the right attorney that you're comfortable speaking with, and you can go into these digital assets and really explain what your estate is going to look like and what you're into. So I've had clients who had, for example, an NFT horse, I think years ago. So it was an NFT, a non-fungible token, and it was a horse, and he did something and he paid something to feed the horse. And for the life of me, I'd never had an NFT horse. I didn't know what it would take, but it was important to him. He had had horses all his life. And so what we had to do is make sure that his estate plan had some kind of provision for that NFT horse. So hopefully you've got a good relationship with your attorney where you can explain, here my priorities are, here's what I'm interested in. And if you go to an attorney who says, I've never heard of Bitcoin, or I think an NFT horse is the dumbest thing ever, maybe they're not the right attorney for you. And maybe you find someone else who has a better understanding of where your real legacy lies.
Absolutely. Absolutely. And so anyone who's, hearing the story today and realizing, boom, wow, I've made gifts like that. And I don't have any documentation. Seems pretty easy, right? Andrew, what's the first thing if someone's saying, oh my God, I've made some of those kind of gifts? What should they do today to protect themselves and their family?
If nothing else, I would grab my phone and open up my Apple Notes or whatever note you have on there and just list them out, just so you have them written down somewhere. And then you can work from that outline as far as, do they need to go into your estate plan? Do you just need to tell your attorney? If you haven't worked with an attorney before, it's good to at least have that context. And then maybe it's a good time to reach out to an attorney and say, listen, I've got 4 kids. I've given my oldest son $75,000 in the last 2 years, but the other three have got about 5,000. I want to make sure I'm equalizing things out or giving some more to the other three. What should I be doing? It may be a full will, or it may be you already have a will and we're just doing a short codicil, which is the fancy legal term for an amendment to your will. That's usually about 1 page long. It just has to be signed, witnessed by 2 witnesses, and notarized. And we can have a shorter update just to explain what's been going on. So I think the hardest thing to do is not do anything. So let's take that first step. And if nothing else, grab a note or even a notebook. Some of my clients have notebooks where they keep all of their family notes in and just write everything out, get it out of your head. There's that old David Allen concept of getting things done, and the worst place to store things is in your head. So we want to get it out and put it on paper somewhere so that we can then take that paper and move it forward as it needs to be.
Yeah, the 3 Ds:
Mhm.
documentation, 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 right?
Absolutely. Yep. And any lawyer is going to tell you that. We love documentation, whether it's an email, a text message, whatever it's going to be, a handwritten note. But we love it when you document things, because when you don't document things, well, maybe we don't love it when you don't, because when you don't document things, we make a lot more money because then we've got to go to court and sort everything out. But from a conservative lawyer's standpoint of not wanting you to get into legal disputes, we like everything to be documented.
Absolutely. Yeah, I know, gosh, probably 35 years ago in business, one of my mentors was like, at the end of any kind of an important meeting or this, memorialize it. Even if it goes nowhere, write this stuff down. And I'm still in the habit of keeping a journal every day of, the things that happened during the day, just so I have all those notes in the background, and becomes critically important if I'm going to, send you a bunch of money. Right. So I love that. So you've built your reputation, which I love, on simplifying complex issues, making it, user friendly. How do you approach your clients to talk about uncomfortable topics like money and gifts and fairness between the kids?
I just try to have that open line of communication as best I can. I want them to feel comfortable with me. And again, it goes back to making sure you have an attorney you're comfortable with. I've had a lot of clients come to me who they worked with an attorney in the past and it just wasn't a good relationship. They felt they were either condescending to them or talking down to them and not really understanding what they wanted. And so we struck. I often talk about my mother being a librarian and the importance of education. And so my goal is to educate people. And if you're going to be doing an estate plan with my office, we want to make sure you understand everything before you sign it.
Absolutely. Absolutely. So another thing before we go, because we've got a little bit of time here. So I had seen another article or blog you had done on, and correct me if I'm wrong, but you said, I think it was 6 documents that every business owner needs to have. And I know our audience, we've got a
Mhm.
lot of entrepreneurs and business owners on here. I think this could be pretty helpful.
Absolutely. And so these will be six documents beyond your will. And the first is going to be either an operating agreement or a shareholders agreement, depending what kind of business you have. Even if it's a single member LLC, what we can often do is have your interest be transferable upon death, which is like a beneficiary designation, so we can keep your business out of probate court if something happens to you. The second, we want to have that buy-sell agreement. So again, if you have a partner and someone passes away, we want to have all of the provisions and structures in place to make sure that we have a smooth transition for the deceased person's interest in the business. We want to have a banking resolution would be number three. So on file with your bank and usually kept with your corporate records, who's going to have access to the bank accounts, and if something happens, who would be able to step in. And that goes into number four as well, which is usually a power of attorney for business operations. So especially in these smaller businesses with one or two owners, we want to make sure there's a power of attorney documenting who can manage the business if something happens to one or both owners. An agreement that I've been working on recently with clients is a key person insurance agreement. So we have a couple of owners, and if one of them were to pass away, we want to make sure that their family is being properly compensated for all the work in the business. So you can get a special kind of insurance called key person insurance that essentially pays to the business. It's like a life insurance policy. When someone passes away, that money is paid to the business, and the business can then pay to your family as payment for your interest in the business. And if you don't have the key person insurance, the challenge is, does the business have enough cash on hand to be able to buy out your interests? And a lot of businesses don't keep that much extra cash on hand to be able to buy someone out. And the final one would be an emergency operations manual. So this is not really a legal document as much as just having systems documented as to what happens. So if there's ever an emergency, people know where the important documents are, where the bank accounts are, client lists, vendor contracts. We want to, these days, it's really easy to create SOPs and other systems. You can use AI, you can use all kinds of software. We just want to make sure, just like we were talking about on the estate planning side, let's make sure everything is documented. So if anything happens, we all know where to look and what the next steps are.
Yeah, absolutely. Yeah, it takes me back a number of years prior to starting My Life and Wishes, and we had a company called ISG Advisors. We were an employee benefits consulting group, and we had a good team of about 10, 12 people. And one of my most valuable assets was a young lady named Jenny Boudreau. She was our marketing person, and she did everything. She handled the CRM. She got all the newsletters out. She had everything else. But if something had happened to her one day, she didn't show up to work, she was incapacitated or worse, we'd have been completely lost. There was no operating procedures in place. No one knew, how to access, the programs and the files that she utilized. And it becomes so important today to have those things in place.
Yeah,
Those are very,
yeah,
yeah,
especially if you're the only person running your business. I mean, your spouse is not going to know what to do. You can think that they understand your business, but 99 times out of 100, they don't know what you do or how to do it. Or, like my wife is not a lawyer, so she couldn't just step in and run a law firm if something happened to me. So you need to make sure you have everything documented.
yeah. And those buy sell agreements and key person
Mhm.
agreements are critical because most people, if they're business partners, they don't want to um, have as their new partner your husband or wife or whomever after the
Mhm.
fact. Yeah.
So I started my career doing family law in New York City. And the person you really don't want as your business partner is the recently divorced spouse of your business partner, who now has taken half of their share of the business. And if you think they're not going to grind that business to a halt and make everyday operations as miserable as possible, you've never been near a divorce case.
You are one of many estate planning attorneys that I know who early in their careers were in family law.
Mhm.
They became increasingly exhausted from all the fighting,
Mhm.
and this is just such a and again, not that there doesn't end up being fighting in estate planning, right?
Mhm.
But it's designed to prevent the fighting
Mhm.
that happens amongst families. So it's just such a proactive uh, kind of law. And again, for The 50% of our audience that are listening and you don't have an estate plan yet, do it. Do it. Do it. If you're in the Minnesota area, contact Andrew for sure. At least reach out, have a conversation with him, see if he's the kind of guy that connects with you. Personally, I think Andrew connects with most people quite well. Where else do you practice law? Are you just in Minnesota?
So I'm also licensed in New York, New Jersey, and Connecticut. So that's done usually, most of my lawyering is done virtually with clients. So a lot of it's done over Zooms and over the phone, and then we'll meet when it's time to sign documents. So for the folks on the East Coast, the timing may be a little different as far as when we can get you in to sign documents. But so it's Minnesota is where I primarily am, and then I'm also licensed in New York, New Jersey, and Connecticut.
Fantastic. Fantastic. So before we wind down, I always want to ask a question.
Mhm.
Is there anything that I didn't ask you that you're thinking, man, I wish you'd ask me this question?
I think probably the role of digital assets and how we plan for them. I think one of the things I've been really digging in recently, and you can, it's almost like a question back to you is like, what's the best way that we can really manage all of these digital assets going forward? So there's a lot of companies out there. There's a lot of different places that my clients are always trying to figure out, I've got some crypto. Maybe I have that NFT horse. More likely, we just have some online banking we're doing, my social media profiles, and really, how do we manage what never was there before? So, I just talked about how over the weekend I took my boys to see Back to the Future, and if your estate plan's from 1985 when Marty McFly is flying around his town, it's really time to update now because a lot of the things we do today in estate planning weren't even they were not even on the forefront. Nobody even thought about these things. So I think the challenge is of how do we plan for these digital assets?
Absolutely. Yeah. And, obviously, the best advice is to work with a professional estate planning attorney.
Mhm.
What we suggest to people, and I'll make a shameless plug for the Legacy Vault by My Life and Wishes, but there is a place to store and record all of your digital assets and identities and provide instructions for family to be able to take those down and access those accounts, accessible 24/7 from anywhere on the planet. At my age, I have many deceased friends with active Facebook accounts because families haven't figured out how to get Zuckerberg the death
Mhm.
certificate and gain
Mhm.
access to it.
Yep.
In my case, if I don't make it home tonight, my family would literally be able to go into my Facebook, my LinkedIn, all my accounts and delete them, take them down. If there's cryptocurrency, they all know exactly what wallet it's stored in and the 32-digit encryption key, because again, there'll be no paper trails of those out there. It's so important. As I say,
Mhm.
when I grew up in the 1960s, death was pretty simple. You know, um, there were one or two banks, there was an attorney in town, there was no technology, and any debt or obligation a person had would show up in the mailbox out front of the house sometime in the next 30 days.
Mhm.
Today, the only thing showing up in that mailbox out front of my house is pizza flyers, window replacement offers, and once a year a birthday card from my mom. So
Yep. Well, and that 24/7 access is so important because unfortunately life doesn't happen from 9 to 5, Monday to Friday. And being able to access things on the weekends if something happens or someone has to go in the hospital on a Saturday night, back in the day, you would wait till Monday and maybe you could find the documents in time. But now, if your attorney uses a client portal like I do, if you're using other online systems, that 24/7 access is really important these days because, unfortunately, life doesn't wait for Monday morning at 9 a.m.
absolutely. Absolutely. So this has been awesome. I really appreciate you joining me today, Andrew. Before we close it out, how can our audience connect with you if they have questions in general? I know you have a lot of resources on your website.
Sure. Yeah. My website, Andrew, Amazon Mother, Ayers.com. You can find me on LinkedIn. You can reach out and connect and send me a DM there. There's a YouTube channel under Ayers Law, AYERSLAW, or you can go to ayerslawtv.com and that'll redirect you to the YouTube channel. So, find your favorite social media, pop over to LinkedIn, hop on my website. I'm always happy to chat. Even if I'm not able to help you, let's say you're not located in the states where I practice, I usually have a referral to an attorney in your state, someone that I know, someone that I trust, and that I would think would be a good connection for you so you can speak to someone local and understand whether so one of the biggest challenges we run into is people will move and then they're not sure, does the will go with them? Do they have to do a new will? And so I always encourage people, if you're moving to a new state, at least take that estate plan and meet with a local attorney and make sure you don't have to do any updates. And it's not that there's something wrong with your old plan. It's normally that your new state has something you can take advantage of that your old state didn't.
That's fantastic. That is fantastic. And again, thanks so much for joining me. And a powerful reminder that even the smallest details, like a Venmo note, can change everything. So if there's one takeaway for our audience today, is this: document your intentions and communicate clearly. Don't let any misunderstanding rewrite your legacy. If you want to learn more about Andrew's work, grab a copy of his book, How Contracts Become Lawsuits. Check it out at his website, as he mentioned, andrewmayers.com. And I've included all of his contact links below in the show notes. And if today's story hit a little close to home, it might be time to get your own affairs in order, your digital life. That's exactly why we created the Legacy Vault by My Life and Wishes, to make things easier for those you love when it matters most. So until next time, this is Jon Braddock reminding you, your life is your legacy. Some secrets shouldn't be taken to the grave, and some gifts shouldn't be left to interpretation. So plan ahead and make it a great day.